So welcome everyone. Before we get started, kindly note that Chatham House rules apply to this webinar, and in practice it means that anything said or opinions expressed during the coming discussion should not be quoted against or held against or used against our guests, and we thank you for that. Today you're joining us for an event that is part of the GAP Symposium 2020. The GAP stands for the Delos Guide to Arbitration Places. It is designed to assist in-house counsel, corporate lawyers, and arbitration practitioners with efficiently accessing key insights into a large range of jurisdictions. The GAP was nominated for the 2019 GAR Award for Innovation, and our symposium is this symposium is our very first gathering of the entire GAP working group. We've had several roundtables and other events limited to the working group, and a few events such as this one to celebrate the occasion with our friends and colleagues in the community at large. Now, 3 such friends and colleagues have joined us as our speakers today, and so it is my privilege to introduce them. We have Lucy Martinez, who is an independent counsel and arbitrator. She is based in Australia and the UK, as you can tell from the background picture. She has extensive experience representing private and sovereign clients in disputes relating to investment treaties, contracts, and national investment legislation. She has also sat as arbitrator, sole, co-arbitrator, or presiding in disputes seated in Hong Kong, London, Singapore, and Australia. Her industry experience includes energy, telecom, satellite technology, banking and finance, insurance and reinsurance, trademarks, shipping, and gambling. She has been recognized in Who's Who Legal Arbitration and Future Leaders, and notably as one of the most highly regarded individuals since 2017 and every year since, along with UK Legal 500 as a ranked practitioner for dispute resolution and public international law, and as a next generation lawyer. She also advises on various international pro bono projects. Next, we have James Nicholson. He leads FTI Consulting's economic and financial consulting business in Asia. He has over 25 years of experience as a consultant on matters of finance, strategy, and economics. Since 2005, his work has primarily involved issues of identification and valuation of lost profits and evaluation of businesses, financial assets, including shareholdings, and other assets, and of wasted costs. He has testified more than 35 times, of which 4 virtually, and I will hazard a guess that was this year, but he'll tell us, before commercial and investment treaty arbitration tribunals, the Singapore High Court, and the Singapore International Commercial Court. James is president of the Standing Committee of the ICC's International Center for ADR and a member of the Executive Committee of the FIA. Finally, we have Noah Rubins QC. Noah is the head of the International Arbitration Group at Freshfields Bruckhaus Deringer's Paris office, and he also leads the firm's CIS and Russia Dispute Resolution Group. He has advised and represented clients in arbitrations under the major rules of arbitration and specializes in investment arbitration, particularly under the auspices of bilateral investment treaties and the Energy Charter Treaty. He has also practiced law in New York, Washington, Houston, and Istanbul. He has served as arbitrator in over 40 cases, including 2 investment treaty disputes, adjudicated under the UNCITRAL rules and 1 under the ICSID rules. Noah has published widely in the field of arbitration and is a frequent conference speaker. He is also the author, with his colleague Alexei Yadikin, of the GAP chapter on Russia. Finally, to introduce myself, I'm the president and the founder of Delos. I also act as an independent arbitrator at Virgi Arbitration, and I'm finally the general editor of the GAP together with Thomas Granier. To conclude this general introduction, this event is also supported by FTI Consulting and Freshfields Bruckhaus Deringer, and so we're glad to have their support and to be doing this together. Now, for those who've just joined us, because some people have been signing up late, I just want to remind them that Chatham House rules apply to this webinar. So to get ourselves started, our event today is divided into 3 segments. The first one will address the Black Swan concept. The second one will focus on quantum and valuation questions. The final one will consider certain significant additional issues that may arise in this context. Each segment will conclude with a Q&A, meaning that we will have 3 Q&A sessions. Depending on the questions, we may defer answering some questions to a later segment of the event, but we will try and make sure that we have covered all of your questions. And you can put your questions using the Q&A function at the bottom of your window. And we'll note who is asking the question unless you indicate otherwise. Now, one thing we wanted to find out before getting started is who is with us today. And so I'm going to end the first poll that nearly all of you have filled out. And it turns out that we've got about as many counsel as expert, roughly 35% of each. And then for the rest, about as many arbitrators as people who identify as other. So with that, let's get started. And the first segment of our event addresses the Black Swan concept. People used to think that all swans were white. So referring to a black swan was a common expression of impossibility. That is, as Lucy will tell you, until the discovery of Australia. Black swans subsequently came to refer to the idea that a perceived impossibility may later be disproven. Lebanese author and NYU professor Nassim Nicholas Taleb developed this idea developed the idea in 2001 that black swans could refer to a type of event with 3 attributes. First, that such events, so black swan events, would be outliers. Namely, they would lie outside the realm of regular expectations, because nothing in the past can convincingly point to their possibility. Secondly, black swan events carry an extreme impact. And thirdly, in spite of their outlier status, human nature makes us concoct explanations for their occurrence after the fact, making them explainable and predictable. Now, that description was taken from a book he published in 2007 entitled The Black Swan with capitalized letters. And this brings us to our second poll, which I will bring up for you now. Let's see. Is the COVID-19 pandemic a black swan? It will be interesting to see what all of you say, and we'll address the results of the poll as part of our discussion. So as you saw, there were 3 options. It's fine to say I don't know, but it would be interesting if you have an opinion. So about 2/3 of you have voted so far. And I should reassure you, your answers are anonymous, so we can't see who's voting what. Right, so it would seem that a majority believe, I'll show you what the common belief appears to be, that the pandemic was a black swan event. That's 44% of you. 37% believe it wasn't, and 20% are undecided. And we will answer this question as part of our discussion. Let me close the results. But we want to discuss some preliminary matters first, and we'll begin with the money. We'll not go in any detail today into claims for declaratory relief, even if some of our discussion will be relevant to those as well. So I'll start with James. Could you catalogue for us, please, the sort of financial claims that might arise from the pandemic? And I will add a second question. Should we be focusing only on claims arising from the pandemic?
Thank you, Hafez, and thank you for organising this this panel, this webinar, and thank you to all of our attendees for taking the time out of your days to be with us. I'll take those in reverse order. So should we be focusing only on claims arising from the pandemic? I think not. I think the pandemic is affecting, clearly has affected the world in a great way since around about March of this year. So it's affecting essentially every business, every project in the world, and so it's now part of the context in which any dispute is taking place. It's part of in any damage quantification, you're comparing the situation that would have existed but for the alleged breaches with the actual situation. So any comparison to an actual situation that arises after March 2020 needs to take into account the pandemic. And so we'll see claims that arise out of disputed events before the pandemic, but that are affected by the pandemic in the damage quantification because of the way the claims are framed. We'll see claims arising directly because of the pandemic, because that caused parties to act in a certain way that gave rise to a dispute. And we'll see claims that are arising after the pandemic, perhaps as a result of knock-on effects of the pandemic, or just in the context of the new world that we're all in. With depressed economies for now and with structural changes that we all expect to come out of the pandemic afterwards. In terms of what types of claim, the easy answer is every type of claim that one can imagine will be affected, but particularly I think we will see claims, and we're already seeing claims coming out of parties pulling out of M&A transactions, pulling out of joint ventures, pulling out of contracts to supply, on both sides, so inability to supply, inability to offtake, or whatever the nature of the customer, the off-taker is. We'll see, particularly in construction and infrastructure projects, we'll see projects being delivered late or potentially not at all, and we'll see buyers of such projects cancelling those projects or trying to minimise their exposure to those projects. And these will all give rise to claims, I would expect, under the usual heads of wasted costs, of lost profits, of lost business value, as well as I'm sure liquidated damages and other types of claim. Also, relatedly, I think we'll see claims for price adjustment in long-term supply contracts, such as gas supply contracts. Both because of the volume effects of potentially of 2020 and the aftermath, but also because of the effects on whatever the inputs are to price adjustment clauses in those contracts. The other area of claim that we often see are BIT claims. So BIT claims, the quantification of BIT claims will be affected in very similar ways. Will we see many BIT claims arising out of government actions that were taken or allegedly taken in reaction to the pandemic? I think that's an interesting question. I suspect that investment treaty tribunals will have will be willing to entertain such claims, but will have a relatively high bar. I expect that they will give governments fairly wide leeway to take action in the extreme circumstances of 2020. But one can still envisage such action being taken in ways that discriminated against foreign investors or violated BITs in other ways.
Sorry, yeah, I froze.
I don't know if you were just talking.
No, my internet froze, as I guess these things happen. I think I got the last thing you said. Thank you for that. Now, to get to this to get to those issues, we need to first cover our basis on breach, causation, remoteness. And maybe I'll turn to Noel for this. Are there specific considerations to bear in mind as a result of the pandemic, or can we look at these questions as per usual?
Clearly the basic legal rules relating to damages remain unchanged. And I'll leave aside breach. That depends on the contract. But in terms of the rules of causation and remoteness, the rules remain the same, but the way in which tribunals are going to deal with causation and remoteness in specific cases involving a background of pandemic remains to be seen. So a typical example with respect to causation, presumably a lot of respondents in arbitration in all kinds of disputes will be saying the damage you say was caused by my failure to perform the contract was actually caused by the pandemic. In other words, you say that your profitability is lower or you didn't get contracts A, B, and C because of my actions, but actually you wouldn't have gotten them anyway. You wouldn't have reached that level of profit anyway because some or all of the decrease in your profitability was caused by the general nasty economic situation we're all in. And it will be, I think, a challenge on both sides. But remember, the burden of proof will normally rest with the claimant to demonstrate causation. So it will be for the claimants to say, no, I would have succeeded despite the downturn caused by the pandemic. With respect to remoteness, you can imagine a situation where, for example, in construction projects, where an employer brings a claim against a contractor for getting a slow start on a project, let's say 2 or 3 years ago. And if it only had performed on time, the financing would have been in place before the pandemic began. Right? But you slowed down, you breached your obligations to deliver design drawings on time, for example, or the material required for a feasibility study. And because I didn't have that, as was expected by the end of 2019, the entire market had collapsed and I couldn't get the financing and I had to abandon the project. So you're responsible actually for the collapse of the entire project. Well, that may be a question of remoteness. That is to say, could the damage caused by a relatively modest delay have been foreseen, when in actuality it was a massive impact? That is to say, it may actually be quite straightforward to demonstrate that financing that would have been in place in December 2019 was not available in April of 2020. So that would be an example of a challenge in terms of remoteness. Now, force majeure is an issue that's going to come up again and again, and it's hard to generalize, although in some legal systems there are general rules about what constitutes force majeure. In most common law systems, and in particular under English law, there is no definition of force majeure. It depends entirely on what the parties have agreed would be force majeure. One thing seems clear is that a pandemic of this magnitude is likely to fall within the scope of most force majeure provisions, and indeed many talk about health crises or the like. The question will more likely focus on causation. That is to say, almost all force majeure provisions that are well drafted will indicate that a force majeure event will excuse performance only in circumstances where the force majeure circumstances actually prevent performance. And that will be, again, depending on the facts, a challenge to demonstrate. In a case in which I'm involved now, a pharmaceutical company had a contract with a Chinese distributor who had a minimum purchase obligation of the drug in question. So every year it had to purchase 20 million doses or whatever for sale in China, and the minimum purchase was not achieved, and the Chinese distributor said, "This is force majeure. We're in the middle of a pandemic, and I can't sell that much." Because no one's doing the operations for which this drug is required. It's a transplant medication. no one's doing these kinds of transplants because they're not priority operations. And so there's no market. Now, the obvious response to that is the pandemic didn't stop you from buying the vials, the doses. Arguably, it didn't even stop you from selling them. What stopped you from selling them was the economic downturn and other circumstances that came out of the pandemic. And so I think that sort of situation will lead to a lot of disputes about whether force majeure, whether the pandemic actually excuses performance.
Now, I should maybe clarify for our viewers, we're going to have a bit of an informal approach between the four of us. So Lucy, James, if you want to comment as we go along, obviously feel welcome to do so. And I don't know if, for example, Lucy, did you want to comment on what Noah just said?
Well, not specifically on causation and remoteness, but we can talk about data valuation if you'd like, or would you prefer to stick with causation for now?
No, sure. No, I mean, I think that's definitely a good point to move on to.
Very good. Well, thank you very much to Delos, FTI and Freshfields for bringing us all together today. We were provided with the list of attendees before this session, and it's a really impressive list of people from literally all over the world. So this is actually one of the silver linings of the pandemic, that even though we can't be together in person, we can all dial in from literally all over the world, and at least 4 of us can see each other, and you guys can see a few more of us. So this is one of the upsides of the pandemic and the wonder of the internet. But my topic for now is the date of valuation, which in fact, one of the questions that have come in has very presciently touched on how do we deal with data valuation issues? And it is a complicated question. I almost always agree with Noah, and I will agree with Noah here where he said that the basic legal rules remain unchanged. And it's the same in data valuation issues as well, that it remains unchanged. What is the law that is to be applied to this question? And as you may know already, depending on your level of expertise for those who are joining us, there are 2 real options. The first option is the date of the breach, whether it's breach of contract or breach of treaty, and you use that as the date of valuation. And that has been the traditional approach, certainly in most common law countries, to go with the date of breach as the date of valuation. And that's also been true in investment treaty cases involving lawful expropriation, and we'll come back to that. But then the other alternative is to have the date of valuation as of the date of the award, i.e. a much more recent date, depending on the facts of the dispute, certainly more recent than the breach, because of course the award will come out after the breach. And this does intersect with the discussion of hindsight, which we'll come back to later in the webinar, time permitting, but these issues do really intersect. So as I've said, the traditional approach was to use date of breach as the date of valuation, but there's been a recent shift. The foundation was laid almost 100 years ago, but there's been a recent embracing of using the date of the award as the date of valuation. And that's particularly so where the relevant asset or business has increased in value after the date of the initial breach. And lest you think that this is a hypothetical or not particularly important issue, it can be hugely important in terms of quantum. And for example, in the very famous UCOS v. Russia award that came down in 2014, it was a $22 billion, that's billion with a B, distinction between which approach you took. The date of valuation as of the date of expropriation, which the tribunal found in that case was 2004, and the value, and as opposed to the date as of the date of the award in 2014. So it's big bickies involved here, and that's why there's a lot of legal time and expert time that goes into the question of the valuation date. And it's primarily a legal issue in that the lawyers generally instruct the experts what the date of valuation should be in any given case, and the tribunal will decide that as a legal issue. However, often, as we all know in these big cases, we get our experts on as soon as possible, preferably even before you file the request for arbitration. You get someone like James and his fantastic team at the FTI group to help us work out what is the quantum of the case, and also whilst he remains entirely independent, of course, he will help tell us, just if you run the numbers, what is the best date of valuation for your case? Is it the date of the breach or the date of the award? And in cases of unlawful expropriation in investment treaty land, then it's up to the claimant to decide which approach they want, date of breach or date of award. And that is consistent, as you might recall, I said the foundation was laid more than 100 years ago. This all flows from the seminal case of the Horsau factory or Chorzau factory or Horzów factory, depending on your level of familiarity with Polish. And this was a very famous case from the Permanent Court of International Justice from 1928, that you will see cited in almost every investment treaty decision on quantum, rightly or wrongly. There's a bit of a debate about whether or not it should be cited, but it is cited. And it was also confirmed by the Iran-US Claims Tribunal in 1987. And then in the investment treaty world, it was not until 2006 was the first reported investment treaty decision that used the date of award as the date of valuation as opposed to the date of breach. Since then, a number of other cases have done it, but it is one of the newer facets of quantum and data valuation. And in fact, one of the other decisions that embraced this approach was the ConocoPhillips v. Venezuela 2013 decision, which Noah and I worked on for many years, and we had a lot of discussions about quantum issues, including data valuation. So it has now been embraced in a number of cases, but obviously each case is unique. It depends on whether you're looking at an investment treaty case, a contract case, whether it's a lawful expropriation, an unlawful expropriation, what the governing law is, international law versus domestic law. And just to add to the panoply of options, some tribunals have also adopted an in-between approach where they use a date of valuation, not the date of the breach and not the date of the award, but an in-between date. For example, there was the case of Unglaub v. Costa Rica, another investment treaty case, because of course, these are the ones that are publicly available and thus that we can refer to. And they looked at a data valuation at a time that the market was most favorable to the investor, because the tribunal thought this was, quote, the fair and reasonable approach to take in that circumstances. So there's lots of different ways that you can approach it, date of breach or date of the award. And that's the theory, and as I said, it's a legal issue. But turning to the practical applications of that theory, we talked about the UCOS and the real world value of the difference in approach, but we can all easily think of assets and businesses that will decrease in value during the pandemic: hospitality, travel, airplanes, any restaurants, anything in that space. They are probably going to be adversely impacted in terms of their profits and revenues. But we can also think about companies and businesses that will most likely increase in value with the pandemic, i.e. hand sanitizer manufacturers, toilet paper manufacturers. In Australia and the UK, there was a mad run for whatever reason on toilet paper, virtual hearing platforms, the creators of Zoom, which frankly I hadn't heard of a year ago and now I use every day. The people who manufacture laptops and webcams, there's been a huge run on them with us all working from home. And of course, the 2021 jackpot winner, which is yet to be announced, is the pharmaceutical company that will produce the, fingers crossed, safe and effective vaccine that will help us return to our pre-pandemic lives, at least those parts of them that we choose to revisit. So the approach that you take to data valuation will depend very much on the individual case, like every aspect of law and quantum, individual jurisdiction, the supply chain to that jurisdiction, and different countries are handling this differently. So like every aspect, as I said, of law and quantum, it will depend, but these are some of the points for you to think about when you're determining data valuation in an individual case. Now, I said this intersects with hindsight, which we'll come back to, but I know that Noah, you wanted to talk about English law. Do you want to talk about that now or later?
Sure. I'd just say with respect to the cases you mentioned and the ADC, the Hungary case, and the other investment treaty cases on this, to my mind, they are hugely unsatisfying. There's no principled proposition that one can trace really to principles of international law that would give the claimant the option to choose which valuation date should apply. That shouldn't be something at the option of one of the parties. Either it's right or it's wrong. The one point that's been cited, for example, is the need to deter opportunistic conduct by the state. Right, we want to deter expropriation on the prediction that an asset will rise in value. That doesn't make much sense, actually, because precisely the proposition is taking into account only the information available as of the date of breach. And if that's what you're doing, well, then the state would have no particular insight that the investor doesn't have with respect to the future prospects of the asset. And any information that the state does have would be incorporated into its value as using the date of breach. Now, I'm not saying the date of breach is right. And in English law, Lucy, you had said the proposition is date of breach. That's correct and incorrect at the same time. One of the strange things about English law is there is this date of breach rule. It's called that. It's referred to that in the cases, and in practice, it's rarely applied. In practice, there's a fundamental rule of English law, which is the same as in international law, as enunciated in the Herzog factory case. And that is the compensatory principle. The idea is we're supposed to give the injured party no more and no less than the money that's required to fully compensate it for the injury actually suffered as a result of the wrongful act. Right? That's a rule, a fundamental rule of English law, which is actually incompatible with the date of breach rule, because the date of breach rule says even if we know for a fact that today the asset is worth more or less than the parties thought it was worth as of the date of breach, we ignore that information. The leading cases in England are House of Lords cases. One is called the Golden Victory, and one is called Bunge and Nadera. And both of those cases involve charter parties. It's not that important. The basic facts of many of the English cases are a contract is breached or repudiated, and the question is how much were the contractual rights worth? That in turn is largely dependent on how long the contract would have remained in place. Right? For each year, there's a certain profit associated with the contract, which has now been breached or repudiated. And intervening events happen after the breach to shorten the life of that contract. In Golden Victory, it was the war in Iraq happened, and that would have, according to the terms of the contract, brought it to an end early. Bunge and Nadera similar, but it was an export ban on grain in Russia that would have brought the contract to an end. And in both of those cases, the House of Lords by majority found that it would be contrary to the compensatory principle to apply the date of breach rule. And Lord Sumption, who was one of the great legal thinkers of our time, said as follows. He said, there's no principled reason why, in order to determine the value of the contractual performance which has been lost, one should not consider what would have happened if the repudiation had not occurred. And he goes on to say, commercial certainty is undoubtedly important. Commercial certainty is the foundation of the data breach rule, saying everybody should know when they're about to breach a contract what the result will be, right? What the consequences will be. Commercial certainty is undoubtedly important, although its significance will inevitably vary, but it can rarely be thought to justify an award of substantial damages to someone who has not suffered any. Right? Quite nicely put. And so for me, transplanting this into the investment treaty context, I see no reason why the rule should be any different. Why should it be that a date of award proposition is more tenable where the asset has risen in value? Why shouldn't it be the same if it lowers in value? Otherwise, you're compensating the claimant for something that he never would have had. Now, the answer generally, I think, although people don't really think this through, and it's certainly not written in the awards, the idea, I think, is that, well, as of the date of breach, the innocent party had an asset or it had contractual rights or whatever, and they had a certain value. And if it hadn't been breached or expropriated, they could have flipped it to someone else at that moment or the moment after. They could have flipped it. They could have sold it to someone else and realized the full value at that time with no exposure to whatever happened afterwards. But the question is, then do you have to get into whether they actually would have done that? Because if they wouldn't have, well, then the intervening events would have impacted either up or down, right? The value of the asset.
Can I jump in?
Go ahead.
A couple of things on that. I'm loath to take on the legal might of Lucy and Noah, and I certainly won't do that on anything that would be considered a question of law. But Noah, that what you just described from Jonathan's assumption sounds to me, from a valuation point of view, like some fuzzy thinking. You know, if you're valuing as of the date of breach, and I hesitate because I know he's a remarkable man, but you know, if you're valuing as of date of breach, then from a valuation point of view, you do not take into account anything that happens after that date of breach. You're valuing as if you were on that day back in 2017 or whenever it is, based on what you would have known as of that date. If you're taking into account hindsight, you're doing a current date valuation, and that means you
right. I should clarify in Lord Sumption's defense that precisely the result was a date of judgment valuation. That is to say, he wasn't saying we can do both, but you can have your cake and eat it. He was saying that there's two rules that are incompatible. One is the date of breach rule, and one is the compensatory principle, and we prefer the compensatory principle. That is to say, discard the data breach rule and take into account everything, effectively valuing as of now.
As of now. But then I think it's important, again, from an economic point of view, that that's consistently applied. So just to reinforce the point you made, that giving claimants the choice of data breach versus current date is giving them a one-way bet. Right? I mean, there's a right way to do this, whatever we think it is. It's either data breach or current date, most likely, and we should stick to that. And in fact, a colleague of ours has written quite a clever paper saying, you know, giving the claimant an option is a little bit like giving claimants in general a financial option. You know, you've got what you value losses one way, but you've got the option to value losses another way. And with a few assumptions, you can quantify the value of that option. And I think he comes up with a range of a value uplift on a claim of 20 to 40%. But I may misremember the figures, but you can put a value on it, and that's something that actually I've never really. I don't think I've seen respondents argue in these cases where claimants are seeming to want to argue that they can choose. I haven't seen respondents frame it in that way. That might be interesting for respondents to do.
So,
Hafez, we see there's some questions. Do you want to take those now, or we take them later?
Well, if you want to, we can take them now. We don't have to wait for the Q&A, so we might as well just go for them. Is there one that you particularly wanted to address?
No, not particular. I mean, the first one says, this is from Loic, who says, is being a claimant a significant advantage over the respondent because of the COVID-19 context? Well, it depends if you're talking about the investment treaty context, where the answer would appear to be yes. I think in a contractual context, there's challenges on both sides. And I don't think anyone has a particular advantage, but the claimant bears the burden of proving causation. So that's going to be complicated by COVID. So arguably, there's a disadvantage to being a claimant in a COVID situation.
Right. I'm wondering whether we shouldn't use this as an opportunity just to talk about procedural and tactical and strategic considerations, because there's arguments you can make in the case, but then there's also the way you run your case. And for that, I might turn to Lucy.
Great, thank you. And these are some of the interesting, because they are untested questions. We have the foundation of law that we're building on in relation to causation, remoteness, force majeure, and data valuation. But in terms of how the pandemic will impact upon strategy and procedure, we can extrapolate from similar scenarios like the GFC, but otherwise none of us were around for the Spanish flu of 1918. So none of us have lived before. So this is all new to us. So there are different approaches and different considerations that will come into the impact of COVID on an arbitration. And one of the points that was just touched on in the discussion about, is it better to be claimant or respondent, is, and I understand, oh, I'm sorry, yes, Hafez has just explained for us. I didn't know until I got back to Australia. GFC is a term it used in the Asia Pacific to refer to the great financial, the global financial crisis.
Sorry.
Americans, we had a call and I was like, what is the GFC? And I had the same question when I moved back here originally. Anyway, so GFC is the Asia Pacific shorthand for the global financial crisis. So there are a number of issues that come up in the realm of strategy and procedure. One of them is that in terms of the timing of the claim, we've seen this in the GEFC and also today, that parties usually wait to file the claim. They're not rushing to the courthouse, partly because everyone's still in the holy smokes, how do we stay afloat scenario and how do we adjust to the new reality of the pandemic. But as we saw with the GFC, when times are tight, and we've seen this when the oil prices fluctuated as well, when times are tight financially, it's almost counterintuitive, but people actually sue more when money is tight because they're not willing to walk away or come up with a new deal that helps everyone make money. Money is tight, so they will sue, but they usually wait a little bit. And that's what we are hearing and seeing with the pandemic. Lots of clients are saying, I really want to sue, but I just, I've got a notice of arbitration, it's ready to go, but we're just waiting to see if we can negotiate something. I'll come back to that settlement. But so that's one factor, is in terms of timing of the claim. But then once the claim has been initiated, I think there are going to be strategic considerations in relation to negotiating the procedural calendar, which happens in the early part of the case, as we all know. And as we all know, probably those of us on the call, traditionally it is the claimant who is looking to expedite as much as possible and move things through as quickly as possible, whereas the respondent is usually, not always, but usually trying to slow things down. And it may be during the pandemic that the claimant may be the one who wants to delay the claim even after it's been filed, and the respondent may want to expedite because of the financial impact of the pandemic. As long as that's going, it is probable, depending on the asset and the industry in the country, that the valuation will be lower during the pandemic than it will be at the end of the pandemic because of the nature of the disruptions of the supply chains and the depressing impact of it economically and otherwise. So there may be an interesting role reversal between claimant and respondent. And I also suspect that the parties may be more willing to agree to bifurcate quantum related issues, again, for the same considerations, that there'll be a decision from the tribunal on jurisdiction and liability, and maybe on key quantum issues such as date of valuation. And then there'll be a quantum phase, which will probably happen not for at least 12 months, 6 months if it's expedited, when you will talk about quantum. And by that point, hopefully things will have settled down a little bit in terms of pandemic. Now, I also suspect that, as those of us on the arbitration conference circuit, and more importantly in practice, know, there's been a huge amount of discussion about how we can make the expert evidence process more cost and time efficient and more helpful to the tribunal, which is ultimately what the role of the expert is in both court and in arbitration. So there's a very eminent Australian arbitrator called Doug Jones, who's come up with a number of proposals in relation to experts. And I'll just touch on two of them, which I think will get increased attention and probably uptake during the pandemic. The first is that he has suggested that experts should first come up with a joint report setting out their areas of agreement and disagreement, as opposed to the traditional claimants comes in first, then respondent, then claimant, then respondent, and then you have the joint report. So this proposal, which makes sense to me, you'd need to play around with things a little bit, but you have a joint expert report that sets out areas of agreement and disagreement, which is, as we all know, often happens before the hearing, and there can be quite a lot of areas of agreement. And then the experts prepare their separate reports simply on the areas of disagreement, which again is what happens before the hearing. And the suggestion is maybe there's a way we can make that more efficient throughout the process, which at least to me makes sense. He also has a proposal where after the hearing, the experts are released from the gentle caress of counsel and moved into the realm of the tribunal. So the experts now talk directly to the tribunal without parties, without counsel, and the tribunal can ask questions and effectively instruct the experts to come up with the valuations that the tribunal will rule upon in the award. So that first idea, as I said, sounds great to me as arbitrator and as counsel. The second idea, wearing my arbitrator hat, sounds great, but wearing my counsel hat, it does make me a little bit more nervous, because we as counsel like to keep control of the process. And even when we have amazing experts like FTI, we still like to know what's going on with them. And we don't really love the idea about them going off and talking to the tribunal without having instructions from us as lawyers. But as I said, I suspect there'll be more focus on this. A couple of final comments, really the final comment on procedural consequences. As I said, there's likely to be more disputes, and you'd think that generally parties settle when they're both exposed to risk, which is certainly the case during COVID because of this uncertainty. So you would think that most cases should settle, cases that are initiated during or as a result of the pandemic should settle, because each side is exposed to uncertainty on quantum and on force majeure and other factors. But what we are hearing anecdotally, because it's too soon for empirical data, is that both litigation and arbitration disputes are not settling at the same rates. They're much more likely to go to an award or to a hearing. And it's partly because there's no in-person negotiation. So you can't sit down with your counterpart. You can't have the two CEOs or CFOs or in-house counsel sit down and hammer out a reasonable settlement, because no one can be in the same room. And the other super interesting, in my opinion, related phenomena, which again is based on anecdotal, not empirical evidence in the common law world, I should say, I'm only speaking on what I'm hearing in the US, UK, and Australia, is that criminal trials are increasingly resulting in hung juries, i.e. that they can't reach consensus. And that's again because when jurors are negotiating and deliberating is the term, I guess, that they're in much bigger rooms than what they used to be when they're all crammed into the 12-person room, where they have to look at each other very closely in person across the room. And so we're seeing, similarly in mediations, they're much less likely when they're done electronically, they're much less likely to reach a negotiated settlement during the mediation. So it's too soon to say, because we're still in the pandemic and we don't know how this is going to play out. But it may be that cases, as I said, are less likely to settle, which means we'll get more awards, because the tribunal will have to resolve the uncertainty rather than the parties. They might be more likely to roll the dice and wait for the award than come up with the settlement. So there's some thoughts on procedure and strategy.
You unmuted yourself. Do you want to go ahead?
It's the new way of putting up your hand, I suppose. Thank you, Lucy. There's some very interesting thoughts in there. I think there's a number of ways in which the experts could be used more efficiently and more effectively in arbitration and in litigation. But I think particularly in arbitration, the reason we're not already doing them is there must be a reason we're not already using those techniques, because there's procedural fluidity in arbitration. The parties can agree different processes, arbitrators can push for different processes. And we don't see much use of the different ways experts can be used. And I think ultimately that comes down to party control and the strong design. You mentioned party control as a factor for some of these, but even I do fear that even the idea of experts getting together early before writing reports would spook a number of parties and probably a good number of counsel as well, although perhaps not all, and/or it would have the effect of front-loading the expert work even more, because the party and counsel would want to have a good idea of where the experts are coming out before they even go into that meeting, so that any discussion, you know what points, so the expert knows what points to push for and so forth. I'd be very happy to be part of trialing these innovations out, but I wonder until party control, or until parties can agree when they're signing dispute resolution clauses to give up some of the control that they would typically have in an arbitration. I just worry that it'll be slow. These things will be slow to be adopted. I think another procedural aspect that we'll see here is that any valuation being done in 2020 or the first part of 2021 at least faces a huge amount of uncertainty, not only, well, less about what's happened, obviously, because we can see what's happened, and we've got a fairly good baselines in most industries and most businesses to know what to attribute to COVID. But the next year or two is still, we still really don't know. We as of 2 weeks ago or 10 days or whatever it is, we hope that these vaccines will start changing things in a big way in the middle of next year. That there may be some setbacks to that. There may be rollout difficulties of the actual vaccination, etc. We really don't know. So there's a lot of uncertainty, and there's some uncertainty as to how businesses, industries will settle down post-COVID, assuming we get to a post-COVID world. And so what that means is that any valuation, any loss assessment being done with a current date now is liable to significant revision through the course of the arbitration process. So say it's an 18-month arbitration process, and say you're filing an expert report in January alongside a statement of claim. The world's going to look very different and hopefully much less uncertain by the middle of 2022 than it'll look in January 2021. And so there's a risk there to the parties in quantifying a claim. That's probably a risk that as it unwinds in ways that will favour claimants, but that's not a given. And again, it'll depend by industry very, very significantly. So there's going to be it's going to be a roller coaster a few years ahead on the damage quantification side, as in so many other aspects of dispute resolution and the world.
So then maybe just to tie up with where this segment started, should we maybe try and answer the question, was COVID-19 or is COVID-19, is the pandemic a black swan event? Do any of you want to volunteer an answer?
I'll go.
Well, both of you go ahead.
Lucy should speak.
No, you go, James.
So regular readers of The Economist will know that the Economist newspaper, as they call themselves, magazine we would call it, will know that every now and then they run an issue or a leader that says, top 5 things that aren't very likely that could really could realistically happen in the next few years and would have a massive impact. And up there are things like I don't know, accidental nuclear war and so forth, but also always up there has been, as long as I can remember, some kind of pandemic. So I think that the fact that people who think about these things, who think about things that are unlikely but not bizarrely unlikely, the fact that the people who think about those things have been thinking about pandemics means that it probably doesn't fall under the tailored definition of a black swan, even if I think we all have experienced it as a unlikely event, which obviously has had a huge impact.
Yeah, and I agree. So I think the poll was about 45% saying yes, 37% no, but I'm with James and voting no, that it's not a black swan. And that's because you might recall the elements are, one, it has to be an outlier. One, it has to be an extreme impact, which there's no doubt this ticks that box. It is extreme, capital E, but it has to be an outlier, i.e. it has to be unpredictable. And as James has said, people have been talking about this for a long time, a global pandemic for a long time. And the most obvious analogy is the Spanish flu, which is misnamed because it actually probably originated in America, but due to World War I censors, they were concerned it would adversely affect morale if it was called the American flu. So they were allowed to talk about the Spanish cases. So it became known as the Spanish flu very unfairly. Wearing my Martinez heritage, it requires me to say that it's really the American flu. So we had one of these just over 100 years ago. So it really is not an unpredictable event. And indeed, most first world governments have had backup scenario, maybe all governments, I just know have access to the first world government contacts, have had backup plans or at least pandemic plans for years, even if they have been implemented to varying degrees of success in varying countries. So I vote no, not a black swan, even though it is obviously extreme.
And I'll add to that the person who coined the term Black Swan, Nassim Taleb, he himself didn't consider this to be a black swan. And he stated it publicly in various fora. So maybe we'll conclude then this first segment with the Q&A. Let's see what questions, oh wow, there are quite a few have been sent to us. This one is more of a comment, sorry, go ahead.
Well, no, I was just going to respond to Andrew Flower, who makes the excellent point that it's probably not true that you can say overall the value of toilet paper has increased. My glib example was too glib. Oh, no, in that, yes, there was a short-term spike in demand, but the long-term demand has not changed. But, you know, it is an example. There were certainly some pretty interesting times in Australia when there was no toilet paper anyway. Yeah, there's some excellent points being raised here in the chat that I agree with. Do one of you guys want to take one of the other ones or move on?
Go ahead.
I can take, where was it? Yeah, so isn't this is going back to this question of valuation date for expropriation? Isn't there also the principle that compensation for an unlawful expropriation shouldn't be lower than for a lawful expropriation? I think that's got to be right. The question is whether it would be any different. That is to say, you know, for a lawful expropriation, I suppose it wouldn't be a bad argument to say, well, if it were a lawful expropriation, then compensation would have been provided promptly after the expropriation. And therefore, it would not have taken into account intervening events. But that can go both ways, right? So precisely, yes, it shouldn't be lower, but it shouldn't be higher either. I mean, that's the, it seems to me that, whether it's lawful or unlawful, normally the compensation is supposed to be based on fair market value. And the question is not what the standard is. The question is, how do you calculate fair market value? Should that take into account supervening events or not? And that's sort of a question as to, it goes back again, it's circular. When are you assessing fair market value? Are you assessing it as of the date of breach, or are you maybe the answer is, well, they're different. If it's lawful expropriation, then it has to be assessed as the date of breach, because that's when the compensation would have been provided. Whereas if it's unlawful expropriation, we do the same exercise, but now. But the problem is that's not what tribunals are saying they're doing. They're saying we're giving the claimant an option as to whether you do it then or now, if it's an unlawful expropriation. That just seems to me illogical.
There's an interesting one here from Daniel Mueller. Would that be the pronunciation? I hope that's close. What would be a free of COVID valuation date? There's surely not a clear-cut answer. And how would we get at that? And the impact and reactions have been different in different regions. That's a really interesting question. I think there's sort of a 3-month window, perhaps from December last year through to March. So I think by the end of March, I was looking at some economic data earlier, and by the end of March, pretty well the whole world economy had gone into free fall. And the first reports were coming out in late December, if I remember right, of this sort of strange virus in Wuhan. So somewhere in that window, would a valuation be COVID-free, and how would you tell? And I think the first time I thought about it, but I think you would look at what was known and expected in the country, or in the industry in the country, or in the geography that you were looking at the specific date. And so I think you'd look at signs as to what actions other actors in the economy were taking, what actions the parties to the dispute itself were taking, broad range of indicators such as local stock market reaction, relevant stock market reactions, et cetera, to see exactly what were the expectations relevant to the specific project or business you're looking at the date that you're looking at it. It is the kind of valuation question I think that valuers try to avoid, because it's very hard. and it's, you're looking at I think in a relatively small window. But the more general point that there's not a single global impact. There's a range of different local, regional impacts is a very good one, as well as the point that that the impact of different industries has been very different as well.
And I think that I agree with all of that James said, and I think that would also intersect with the procedural decisions about, obviously we can't predict when we're going to be free of COVID, but that would be why the claimant might wait to file the claim, and then even once the arbitration is off and running, they might be happy to delay these things because hopefully we will eventually get to that. So rather than having this wild speculation and uncertainty, at some point things should start to become clearer. And while I have the mic, so to speak, a great comment also by Trevor Dick. I agree with you that even if COVID itself is not a black swan, I don't want to get too political, but I certainly would not have predicted that the United States would be leading the world in deaths from the pandemic. That I think that is unpredictable and an outlier response with an extreme impact. So you could maybe argue that the way that it's played out is a black swan, even though the pandemic itself is not a black swan. So an excellent point.
We have one more question on valuation, and I think that takes us into our second segment. So with your permission, I'll move on. I'm mostly just aware of time that we still have quite a lot that we would like to cover. Our second segment looks more specifically at issues that would arise when seeking to quantify a loss against a backdrop of the pandemic. And to introduce the topic gently, perhaps James, you could give us an overview of different valuation methods.
Happily, Hafez, and I'll be quick on this because I think most of you will have heard most of this in the past. So classically, there's three ways to value a business or a project. The first way is the so-called income approach, where you look at what cash flows the business will or the project will produce in the future, and you place a value on those as of the date of assessment, as of the valuation date, by applying a discount rate. A discount rate means that you're placing less value on cash flows that arise further in the future than you place on cash flows arising more nearly in the future. That's
something lost everyone.
Hafez is frozen again. I'll try to go on. The second way is the market approach. So that under the market approach, you look for the values of comparable assets and you try to read across to the value of the asset that you're looking at. So if you're trying to value a 3-star hotel in Budapest, you might look at the value per room of other 3-star hotels in Budapest, if you can find that data, and say, okay, so these hotels sell, or the value of these hotels is, from transactions, etc., is let's say 100,000 euros per room, and so we've got 73 rooms, so you multiply through and you get your value, and that approach can be applied in many different ways in many different industries, and the inputs for that can come either from transactions in comparable assets, or the data about the buying and selling of comparable assets, or stock market price information, and sometimes some other kinds of information as well. And the third way, which is least helpful in most valuation contexts, is to simply look at what the asset costs to put in place. And that's easier to measure but less informative, because most assets are part of a business project, and most businesses they have a breakup value, right? If you just sell all the assets and break it up and collect what money you can by selling what you can of the business, but that's typically worth a lot less than the value of the business itself, as measured by the cash flows that it would generate in the way that I described. So those are the three main ways of valuing, and the three main approaches typically taken to loss assessment as well in arbitration and litigation.
Thank you, James. So maybe I'll turn to Noah now. What challenges do you see with those valuation methods that take into account future economic benefits in the present context?
I think there's serious challenges, because there's so much disagreement about what the background economic conditions look like going forward, that there's going to be huge variation. Obviously counsel will be instructing experts will say on one side that the claimants will be saying recovery will be fast and will be, we're going to be bigger than ever. We're going to be great. We're going to be huge. It's going to be fast. It'll be like this never happened, and there'll be such a rebound. And the respondents will be saying, "Oh no, this is good. There's going to be a dragging effect for a generation." And unfortunately, there's no solid base on which you can determine which of those perspectives is the most right. So from the perspective of trying to determine both what the magnitude of cash flows will be, and that difficulty will depend on the industry, because some industries will be affected more and some will be affected less by the background conditions. And also the risk profile, that is to say, how will it affect the discount rate? Will there be arguments that, while interest rates are affected and country, the risk of sovereign default will rise in certain countries, so the country risk premiums will rise, but claimants will be saying, I'm not affected by that. We'll say, we're COVID insulated, so none of these effects affect us. Even more difficult, I think, will be comparables analysis, because normally you at least have a window of transactions. I mean, there aren't endless transactions to choose from, and it's always a challenge to find transactions in businesses that are really comparable. And it's only possible because you've got a large number of transactions in general in the world over a reasonably broad period of time. So a period of a year at least. And the problem is here, your window is just shrunk. Anything going back, 6 months from now, before now, okay, so let's take it, last year, isn't comparable by definition. And the question will be, is any, is a transaction that happened even after COVID, but at the beginning, when the uncertainties were even greater, is that going to be comparable? And so I think there's serious challenges in a forward-looking analysis. Now, ultimately, most courts and tribunals are going to say it is our mandate and our responsibility to assess damages once we've become convinced that damages were suffered. And the fact that it's difficult to quantify those damages shouldn't prevent us from doing it. Most legal systems require some level of reasonable certainty, not absolute certainty, but reasonable certainty. And so I suspect that tribunals under different systems of law will be coming to the view that in present circumstances, we just have to lower the threshold of what reasonable certainty is, because reasonableness depends on the circumstances. So, we can't be as certain as we were before, but that shouldn't stop us.
But then, sorry, and I'm going to digress slightly here. Conversely, if respondent is saying prima facie there is no loss, and then going back to Lucy's conversation earlier about strategic considerations, do you see that playing out by with preliminary issues on that very question?
Yeah, you might have, but I mean, it's all rolled up into one. I mean, yeah, some respondents will say your business would have failed anyway. Because in both scenarios, you got COVID-19 and its aftermath, and in the economic downturn that resulted, nothing we did changed history, changed the fact that you were going to fail. And that's a question of causation, but it's a question of modeling in terms of quantification. So I'm not sure that it's so easy to take that as a preliminary issue.
Fair. So then maybe let's talk about hindsight. And for that, I'll turn to Lucy.
Yeah, well, we've touched on this already to some extent, because it intersects with the date of valuation issue, in that if you're using the date of the award as the date of valuation, you're obviously using full hindsight. You look at everything that's happened since the date of breach to the date of the award. Whereas if you're using the date of breach, pure date of breach approach, then in theory, you do, as James was saying earlier, you are meant to look at, say the breach was in 2018, or in theory you would say in 2018, these were the projections that were being used over the next 20 years for the project. So they're the ones that we will use for purposes of valuation on the date of breach approach. Now, you can appreciate that is unappealing to a tribunal to say, ignore everything that's happened with the pandemic and just use the world as it stood in 2018. So often tribunals now are using a mixed approach where they look at all of the data available to them and almost mix and match based on what they consider to be the reliability or substantiation of the data. And that intersects with Noah's point that we don't have that the standards for reasonable certainty will lower. Just because it's hard doesn't mean that the tribunals or the experts or counsel conduct their jobs. And every case will turn on its own facts. Frankly, the more egregious the breach, the more comfortable the tribunal might be saying, yes, the claimants met their burden of proof on what the risk profile of the asset is. And conversely, if it's a very marginal call on liability, that may be a factor for the tribunal in quantum. That's obviously not rigorous and not supported by economics in any way. But when we don't have clear rules during COVID, I think that will have an impact on the tribunal.
Yes, I think claimants and respondents will have to think carefully. Well, they have to think about whether to talk about their claims slightly differently. In the disputes world, we like to get as close as we can to proof, because that's the nature of the game that we're playing. But you only have to look at stock markets and what investment bank analysts, etc., are doing to see that in the real world, people are still taking views on value. They're still ascribing significant value to assets. Investment bank analysts are finding ways to have reasonable approaches, or as reasonable as you can in the circumstances, to valuing assets, to looking through the COVID situation to a post-COVID world, and to adjusting whatever needs to be adjusted for the interim. And so, although you still, as an expert, have to persuade the tribunal that the way that you've done that is the appropriate way, I think as an expert, one needn't be embarrassed that one's trying to do that. I think that's what's happening in the real world. And that's a useful benchmark. We've talked, I mean, a related point, we've talked some about the but-for scenario and how things would have gone for a project or business but for a breach, but in the presence of COVID. There's also quite a lot of room for debate if you're in a situation with a loss that is ongoing, that's going to go after the date at which you're writing your report or the hearing, that the future actual world is pretty uncertain as well. So you see this sometimes, but I think you're going to see it more often in the next few years. There's not only a fight about what the world would have looked at, what for this business or project would have looked like but for the breach, but also a fight about what the actual prospects for that business are given the breach and COVID, because there's so much uncertainty out there at the moment.
Now, I have a question for both Noah and James, which is, we've got, I'm just conscious of time here. We've got a number of things that we wanted to cover. Do you want to make both some quick comments about different industries? Noah, perhaps more about long-term energy projects, and James about M&A and the concept of EBITDA. But I'd say if we talk about those, let's do so briefly, so then we can talk about some of the other issues as well.
James, why don't you go first?
Okay. M&A, we've seen some parties feeling differently about the M&A deals that they were in various stages of negotiating when COVID hit, and we've been publicly reported some examples of deals that have gone on ice or one side's trying to withdraw from altogether. So there'll be some interesting and quite large disputes about those if the relevant parties can't settle. And I think all of the issues that we've been talking about will come up in those contexts. Perhaps though the issue of selecting the date of assessment will be less relevant, because there's a hypothetical transaction that's being disputed that may somewhat crystallize that issue. EBITDA, Hafez, thank you for raising this. This is, so many of you will know of EBITDA, which is basically profits with depreciation and amortization added back in. or a measure of profits with those added back in. EBITDAC is that same measure, but also with the negative effects of COVID added back in. So the idea is to have a sort of but for COVID measure of profits for a business, which isn't telling you much about 2020 and probably isn't telling you much about 2021, but might be, if it's done properly, tell you something about 2022 and afterwards. And like many of these alternative measures of profits, I think if a company's putting that measure forward, perhaps to investors or in its presentations and so forth, you have to take it with something of a pinch of salt. But it is something that investment bank analysts are looking at, that some of them are looking at as one of a number of different ways of trying to place a value on assets in this current context. I think the basic idea is sound, or at least is as good as you're going to get in the current context, which is to try to get some fix on the performance of the business post-COVID, because most of the value in a business is going to lie in, fingers crossed, 2022 and afterwards. And so you take some view of perhaps it's 2022 financial performance if you're doing a multiples-based analysis, a profit multiples-based analysis or assessment. And then you've got the different problem of assessing what's the performance of the business going to be between now and 2022. And that's a combination of a short-term cash flow forecasting exercise on which you will have some data because you'll know how 2020 has played out and for that particular business or project, and an exercise in forecasting whether these vaccines that we're also hopeful about are effective and how quickly they can be rolled out, and therefore how quickly the world moves to a post-COVID state. So I think as valuers we have to be open to these different ways of looking at getting to the values of businesses and projects, because the alternative is just to throw up our hands and say, well, we just don't know. And I don't think that's good enough, and I don't think that's what people who are advising on real transactions, on real in the real investment world are doing. I think they're doing the best they can in difficult circumstances.
I think that's pretty complete. I don't have a lot to add. There will be a lot of stress, I think, on those organizations that project oil prices, because in valuing damages in an oil and gas project, the future price of oil and its trajectory is central, and it's something that already, even without the uncertainty of today, there was a huge amount of variation between sources. And so claimants had their favorite sources, which tended to be optimistic, and respondents had their favorite sources that tended to be pessimistic, and had experts have different ways of combining the sources to produce the result they think is reasonable. But that's going to be harder now, and it's going to be interesting to see how those organizations deal with the uncertainty, and whether it becomes even a wider range on that. That's all I'd add to it.
Thank you. Well, actually, I might just stay with you for my next question, and go straight into the third segment, which is, and the question for you is this: are there any relevant analogies for us to draw between the impact of COVID-19 and the 2008 financial crisis?
Yeah, in a lot of ways it's similar, and this goes more to merits, I suppose, than quantification. In that, in 2008, you had a collapse that many people predicted, by the way. It wasn't unexpected to all, although to the majority of the market, it was a surprise. Otherwise, there wouldn't have been a collapse, right? Because I mean, that's the nature of markets. If they assimilate all the information, they know it's coming, then it's not sudden. But there was, literally overnight, a massive drop in particularly commodities prices, metals, energy, everything, from a historic high to a lowest mark in a decade. And one thing that I think is interesting is, Lucy said, well, people were expected to settle these things, right? But they haven't settled in COVID-19 situation. And maybe that's because they can't meet together. I would suggest that's not the answer. We can't know what the answer is. But in 2008, those disputes didn't particularly settle either. That's my anecdotal sense, is there were a lot of those disputes that went all the way to the end. And the reason is that when a business has less assets, contingent assets seem to be worth more and are more vigorously defended. A litigation claim is a contingent asset, right? So if you don't have so many non-contingent assets, you hold on tight to what you've got. And I don't think that necessarily made parties think they had better claims that they had, but increased their risk tolerance. They had less to lose. And I think that's a similar situation now. The other merits, sort of liability point that's similar to 2008 is states taking steps that in response to the crisis that may lead to claims, and renewable energy is very similar today to the situation that it was in 2008, 2009. So after 2008, we had the Spanish rollback of renewable energy in order to increase budget revenues. And that's what's happening today in Mexico, Ukraine, and now, as of now, France. So we may see a massive wave of those claims as well. And in that way, it's also similar.
As I was listening to you, one of the things that came to mind about contingent assets was the rise of third-party finance, but that's a talk for another day. What I might actually segue to is, given the analogy, what's a temptation for anchoring and for using that as a reference point for arguing a case? And maybe, Lucy, you'd like to say a few words about that?
Great, thank you, Hafez. So you guys may have heard about anchoring, but just to ensure that we're on the same electronic page, so to speak, most people attribute it to this book that came out by Daniel Kahneman called Thinking Fast and Slow. Now, I never read the book but I read summaries of the book. So you may be in the same situation, that we know generally about what the book said. One of the key things that came out of that book was this idea of the anchoring effect, a cognitive bias phenomenon, where a person in any format, not necessarily tribunals or judges or decision makers, but there were some fascinating examples in that scenario. But any scenario, not necessarily dispute resolution, if you ask a person to consider an initial value relating to an unknown quantity and then estimate that quantity, the estimate that they will give is almost always linked to the initial quantity that was given to them. So what does that mean in arbitration is that the theory, and it looks like it's been borne out in practice, there was a PwC survey in 2018 that, in the interest of time, I won't talk through the outcome, but there is some statistical suggestion that anchoring is real in international arbitration. There is an incentive on the claimant to put in a claim for $100 million in the request for arbitration, because that's the first number that the tribunal will see and read. And so the theory is that will anchor the tribunal's expectations about value. And so if they're trying to decide between 100 million and 20 million, they're more likely to go towards the 100 million. Now, one of the interesting realities here is that now most of us are familiar with anchoring as a phenomenon. And so now we almost have cognitive bias trying to go back the other way and make sure we don't, or trying to counteract the effect of the anchoring. But in any event, one of the reasons why we have this issue is tribunals aren't always fantastic at explaining their thinking on quantum. Again, in the interest of time, I won't tell you the stats, but there's been a study done by the analysis group about ICSID awards, again, because they're publicly available. And it does look like tribunals are more engaging with valuation concepts in their awards. So they are trying to not be caught up in the anchoring, but this is one of the hot topics in valuation. And in the interest of time, I'll just leave you that taster and move on. Oh, sorry, one thing I will say, the final point though, is that if there is a great discrepancy between what the claimant claimed and what is actually awarded in the final award, the tribunal can take that into account in allocating costs. So for example, if the claimant claims $100 million, but only was awarded $10 million, then that they shouldn't get all of their costs back, even though they have one on jurisdiction liability and partially on quantum.
True. James, did you want to add anything?
So lots of great thoughts there. The one I'm with an eye on the clock. The thing I think we should keep in mind as well about damages awards is that an award from a tribunal is at the end of the day just a piece of paper. It has legal force, presumably, but it is just a piece of paper, and the claimant isn't made whole, or as whole as it's going to be made until it collects on the award. And collection is often an issue in international arbitration, but the risk of your counterparty being unable to pay an award is even greater. Well, is greater now than it would be normally, because so many entities are in financial distress, and so that's not directly a damage quantification point, but it's something to have in mind, I think, for a party throughout the dispute process is how much money will I actually be able to get from the party I'm claiming against once I've got the award and I'm trying to enforce it.
Thank you. I might put a last question to you, James, actually, before we turn to the Q&A, which is, and just a word so that we've covered it explicitly, with all the support packages and help given out by governments around the world, that will typically benefit a company as a whole, but if rather than a specific contract or deal. But if we put aside disputes that relate to, for example, the acquisition of the entire company, should we be taking into account this support when assessing damages?
It's a very good question, and one that will come up a lot, I think. And the answer is, for me, is yes. I think whenever one's considering how to think about a damage or loss quantification situation, it's always helpful to go back to the but-for versus actual framework. And in the but-for world, you have COVID but no breach. So unless there's something about the breach that meant that the support was taken by the business that's claiming, then you've got that support in the but-for world, and you've got it in the actual world by hypothesis. And so you need to take that into account. Of course, if the support's the same in both the but-for scenario and the actual scenario, then it won't affect the loss quantified, because the loss quantified is the difference between the two. Then again, if you're getting into situations where the survival of the business is under threat in the actual scenario, but not in the but-for, then that may come in as well. So, so the headline answer is yes, absolutely. It's part of the business context of most businesses, many businesses, and hence many claimants, and so it's relevant.
Thank you, James. We're going to do a final Q&A, and then we'll say a few words to conclude. As we're doing the Q&A, I'm going to launch a third poll. So fill it out as we're talking, and then when we wrap up, we'll look at the answers to the poll. And the question that we're putting to you is, when do you think will be that time that we can describe as post-pandemic? So now let's look at the additional questions that have been sent to us in the Q&A. There's one that's directed at, so maybe in order in which they were raised. There was one for James about EBITDA. Why would that tell you something about the future in 2022 when there is so much uncertainty today and tomorrow? Surely this uncertainty in the short term would have an impact on what things would look like in 2022.
It would have I think it would have a value impact. The idea is that you've got very unusual amount of uncertainty between now and, let's say, the end of 2021, and then you're into a post-COVID world from 2022 onwards. So let's sort of take 2022 onwards and try to put a value on that through estimating what 2022 EBITDA or EBITDAC, either way, would be, and there are techniques to value the cash flows in 2022 and afterwards. And then you've got the problem of what happens in 2021, let's say, because we're late in 2020, and there's a couple of questions there. So one is, do you expect the business to survive 2021? And if it does, in what form? Perhaps the lenders take over because there's a default on the debt and so forth. So, but even if the business does survive and survives under its current ownership and structure, there's a question of how much cash does the business burn? Does it have to sell off assets? Does it have to do major restructurings, etc., etc.? I suppose then you need to look at, okay, so what are our answers to those? What's our answer to that? And then does that change what we think about 2022 and afterwards to make sure that you've got a consistent story for the business? And maybe that's the thought behind the question, in which case, absolutely, that's right. If you have to lay off half your staff in January 2021, it's going to be a big job to recruit to double your staff in 2022, if that's what you need to do to go back to business as more or less usual.
Thank you, James. Our next question is addressed at Lucy with her arbitrator hat. How should tribunals approach issues of quantum and valuation when faced with small claims and when faced with situations of stark imbalance between the parties to the dispute?
Well, it's a great question, and one that's not easy to answer. Quite a lot of my cases as arbitrator are on the comparatively lower end of the quantum scale and or their expedited proceedings. So you've got to issue the award within 6 months of the constitution of the tribunal. And that's been quite a contrast from my cases as counsel, where they were usually complex high value disputes that ran for many years involving 10 or 20 billion US dollars. So we spent a lot of time with quantum experts, a lot of time and attention was paid to quantum. Now, of course, the smaller cases are not necessarily any less complex, whether it's quantum or law or jurisdiction, but the parties are understandably often reluctant to incur the expense of a quantum or the perceived expense of a quantum expert in a smaller case. So you do see usually less time and attention paid to quantum. Of course, it depends on the individual case. If it's a relatively straightforward non-payment of invoices or non-repayment of a loan, quantum's pretty straightforward. It does get more tricky when there's questions about causation, and then I find even in the smaller cases you will have experts who will get involved, but at least in my experience those cases have tended to settle, and I think it's partly because of the cost of the experts is a factor. I usually include in the procedural calendar an option or a requirement for the tribunal to issue written questions to the parties. And I find often those questions relate to quantum because they're issues that the parties haven't really bottomed out for one reason or another. In relation to the imbalance point, I've had a few cases where the respondent is not participating. So in addition to the obvious due process grounds, you have to test the claimant's case, but not overly test it and not help respondent defend their case. It's a fine balance to go of testing. You have to ask the sensible and obvious questions that arise out of the submissions. And leading on from that, kind of the opposite of the small cases, one of the excellent questions from Jonathan Ellis, I think it was about the use of tribunal appointed experts. For my smaller cases where I sit as arbitrator, that's just outside the realm of possibility. But I do suspect that that will be used more on the bigger cases, and it may ultimately be more cost efficient, provided the parties can have input on the appointment of the expert and also make submissions to that expert.
Thank you, Lucy. Noah, James, unless you had anything further, I might wrap up. Okay.
I just, yes. My skepticism about procedural innovation comes back. I fear with tribunal appointed experts that you just get shadow experts on both sides that are maybe a bit cheaper, but whether there's a system-wide saving, I don't know.
What we've got to do, because what we're doing right now is just so expensive, and the tribunals often just disregard the experts because they see them as hired mouthpieces.
Yeah, I think parties have to step up and find a way to get costs under control, and they have to choose arbitrators that are going to be going to innovate in these ways and be tough. And they, I don't know. You don't see that. I mean, I don't see that part of the process very much. I don't get the sense that that's happening that much yet. I think it's the part. It should be the party's process. It seems to me, and if they start putting the pressure on, then things will change.
So then, maybe to conclude, James, what would be your one-line takeaway for this topic?
I'm trying to remember the headline. What damages and COVID. It's there's a lot. It's about applying a lot of principles that we're all quite familiar with in a different context, and so there's a lot of innovative thinking, I think, to do around that, and we've talked about a lot of those ideas this evening, today. So we need to do that, but we need to not get too carried away. We're not into some entirely different world. It's the same principles in a different context.
Lucy, how about you?
The only certainty is uncertainty.
And now a final word.
I'll just share some wisdom from a rabbi that I know who, when this all began, sent out a message to people like myself and said, well, look, this may seem terrifying, but actually COVID is a wake-up call. We always thought that we were in control. That was an illusion. We were never in control. And this is just proof that we were never in control. Now, I'm not saying who you should think is in control. Obviously, the rabbi had his own view on that. But the point in terms of quantification is we were never certain. And there was always uncertainty associated with quantification. What COVID has done is brought focus to that in a context where there's so much uncertainty and it's so broad and global that nobody can deny it anymore.
Thank you. So with that word of wisdom, it remains for me to thank you. And we'll try and put together a short report on this for everybody's benefit, but at the very least, the recording of the event will be made available on Delos's YouTube channel. So thank you for those who are here with us today, and to all of those of you who will be watching us afterwards. In exactly 20 minutes, we've got a final event for our GAP Symposium, where Professors Jung-Yi Kim and Maxi Scherer will be discussing the recent UK Supreme Court decision in ENCA and Chubb, and the law governing arbitration agreements from a comparative law perspective. And Thomas Granier will be moderating and sharing some of his recent analysis as well. Now, you can sign up for this event if you haven't yet on the Delos website. And thank you all for your time, and to my guests for joining me today.
Thank you. Goodbye, everyone.